All right, welcome to our voting session. It's Tuesday, March 9th, 2021. We have, how many bills do we have on? 15? 15 bills. We're just going to we'll start off in order. So let's start off with Senator Hettleman with Senate Bill 75.
This bill generally requires a person age 85 or older to appear in person at an office of the Motor Vehicle Administration in order to renew a driver's license. You have one amendment in your packet. That is number 518574/1. This adds to the bill an existing requirement that the MVA notify a person that their license is expiring 30 days before the expiration occurs, and adds to that an additional provision requiring that if the person will be 85 years or older on the date that the license expires, that the MVA must additionally include information on how they can apply for a non-driver's license identification card.
I take that amendment as a friendly amendment. Helps make the bill better. We're fine with it. Great.
Excellent. So then, this is a Senator Castley's amendment, so there's a motion to adopt the amendment. Second, everyone's good? Okay, great. Further discussion? Okay, is there a motion on the bill? All right, motion for favorable?
Second.
Seconded, everyone's okay? All right. Excellent. The motion is passed favorably as amended. All right. We move on to Senate Bill 98.
So with Senate Bill 98, there are two amendments in your packet. I also included a copy of the cross-file bill as passed by the House, favorable with amendments. So this bill prohibits a local Board of Education public pre-K program, non-public pre-K program that receives state funds, public primary or secondary school, or non-public primary or secondary school that receives state funds from discriminating against any person, refusing enrollment of, expelling, withholding privileges from, or otherwise discriminating against any student or prospective student because of the individual's race, ethnicity, color, religion, sex, age, national origin, marital status, sexual orientation, gender identity, or disability. Further, retaliatory actions against a student or a parent or guardian of a student who files a complaint alleging specified discrimination is prohibited. The bill establishes a complaint, mediation, and appeal process for violations. All or part of specified funding may be withheld from a board, program, or school that violates the non-discrimination requirements of this bill.
How many amendments did the House make? Can you walk through a little bit of that?
Yeah, so I didn't include the actual amendments that the House passed, but I have like the reprint. So it should be House Bill 155 if you're looking at that. So the amendments primarily focused on, if you go to page 3 of the bill, looking at lines 24 through 28. So this had to do with the clarification of who this bill is targeting. So it made it explicit that it's a prospective student or a current student. Or individual because of the individual's race, ethnicity, color, sex, religion. There, and then the other amendments appear on page 5 of the House bill, subsection B, and it goes over what the entity is prohibited from doing. So the entity may not discriminate against a current student, prospective student, or the parent or guardian of a current or prospective student on the basis of specified class or specified characteristics. 2, refuse enrollment of a prospective student, expel a current student, or withhold privileges from a current student, prospective student, or the parent or guardian of a current or prospective student because of specified characteristics. And then 3, which was left alone, but number 3 also is limited to students and prospective students and parents and guardians.
Senator Castley, this looks a little similar to at least the first part of one of your amendments. Do you want to explain the first part on 178578/1?
The intent there is, well, the enroll, the change on enroll, I think, was more of a, that's not really it. The issue is person and substitute student, because want to make clear that we're talking about students only and not staff, which is the language that's typically in the annual corrective bill. Let's see, on page 2, striking, I'm sorry. Is it not matching up? Yeah, enroll, Jesus Christ, why is this not matching up? The additional language, we've added in the language, enter into any agreement or take any action that inhibits the free exercise of religious rights of the non-public pre-kindergarten program or non-public school as a condition precedent for applying or receiving funds. So that's saying this subtitle does not require a non-public pre-kindergarten or non-public school 2, and then it adds into the enter into any agreement to take actions, and then the changes to person to student, and then the last change is to deletes 26705, which states that each non-public pre-kindergarten program that receives state funds shall develop and maintain a written anti-discrimination policy. Certain entities don't have any problem with living up to what the statute says, but the idea of actually publishing a policy is very troublesome to them, particularly the Orthodox Jewish community. So the idea that, well, you're going to have to put this in writing and state it as part of your policy is troublesome. So the proposal was, why do we need that anyway? If it's the law, why do you need a policy? Because you're just going to have to act in conformance with the law. And this would apply only to students and not to staff in the private schools. And that's pretty much what the amendment does.
Got it. So you've got 3 parts to your amendment. The House amendment looks like they've handled the first part, which is the student, just clarifying that it only applies to students. Can we just adopt that and then further discussion on the second 2 parts?
On the amendment number 1, the students?
Yes.
Yeah, okay. So on my 17-857-8/1, I move amendment number 1. You want to do 1 and 2, or just 1?
You could do 1 and, because 1 and 2 are the same as, essentially, I mean, they look, I haven't done the line by line, side by side, but it looks like it's the same as what the House just did.
Let me, I want to make sure
I
it
haven't
matches so
laid
there's not
the
a
House
conference
out. Let's see.
for.
The House one only changes it to student in subsection 5, Roman numeral 2. The one that Senator Castley suggests would change it from person to student on page 3 in line 16, which is subsection 5, Roman numeral 1.
Public institution, right?
They go a little farther, it looks like.
So the 4108,
Yep.
each county board, so I think that's why they didn't include that's why they didn't make it to that, because that applies to the public institutions. And then the second one is what applies to the private institutions. this is confusing.
Bob, you want to take some time to look at what the House did? I think it'd be easier to adopt that and then work on your. Yeah, correct.
And then amend from there?
Yeah.
Okay, that's fine.
Is everyone okay with that? Yeah. Okay. Sorry. I haven't been like privy to the conversations that deal with the second part of your amendment, the publication of the policies. Just can we just talk a little bit more about it? I just don't.
With the Catholic Conference, they didn't really care, but they said that in deference to their Orthodox Jewish community, that they really asked us to please back them up on that piece, that there was no need to write in a policy. It is what it is, and they don't have any problem doing what the law requires. It's that to affirmatively state this is our policy causes them apparently no small amount of problems. So, and it seems like that piece isn't exactly indispensable to the bill as it is, so.
So, yeah, I get it. If you participate in the Boost program, isn't it part of the, are you not only already required to do that?
So you have to attest that you don't discriminate in order to be able to get Boost and in order to be able to get textbook and technology money. So, and that has changed and gotten more stringent over the past couple of years, your attestation. So I think that the schools are very committed and solid in their non-discrimination policies. There are some problems with putting it in written, because they don't have anything about these issues in their written policies as it is, but they feel totally comfortable attesting to the fact and signing a written document that they don't discriminate. Putting it in a policy handbook is a different thing.
Got it. So the Boost then, participation Boost doesn't require like the development and publication of a policy. It does not.
Does not. It just is this attestation. And then there is the review of any handbooks to make sure that there's nothing in there that is discriminatory. And there have been instances where institutions have been kicked out of the program because their policies have been in contrast to what they signed.
Yeah, I mean, just to speak up philosophically to what Senator Handelman is saying, like, if we're requiring them now as a matter of law as opposed to as a matter of Boost to follow the law, requiring the additional written policy seems superfluous. Like, when I go down Route 50, I don't write out a note that's saying, I will not speed. I don't speed. That's the law. I mean, sometimes I do speed, but.
So look, all right, for this piece, so this is the same amendment off of the Senator Castley, but this is the amendment 2. Let's subpart number 2.
It's still amendment 1, right?
It's still.
Amendment 1 on page 2, right?
No, we basically adopted what the House did for it's the same goal, but I think their language is their amendments were a little clearer. But now we're on the handbook piece. So it's on page 7 and 8.
I'm sorry, I'm looking at the front page.
Yeah, sorry. And strike in their entirety lines beginning with line 32 on page 7 through line 5 on page 8. Is that right? Just look, if you look at the amendment, just look at the bottom of the page
The House bill or the?
of Senator Cassidy's amendment. Sorry, go ahead.
Yeah, sorry, the page numbers don't match up with the House and the Senate bill. So for the numbers and pages Senator Smith is referring to is the Senate bill.
And the
So,
in line is behind the amendment.
So it's
What-
Senator
what lines we
Cassidy's
striking?
amendment.
So just look at the bottom of the page
Yeah.
on the amendment. That's what we're doing.
Oh, okay. 2675, fine. I was looking at the House bill.
We'll let Senator Sidnor.
No, thank you, and just so that it can be clear to me, why is it that if they can attest to something that they don't feel comfortable putting it into a policy?
It's a little bit of a sensitive. Well,
Because we've gone through and with police reform, and we've said, all right, adopt the policy. Let's see what it is in writing. So, I mean, I'm just trying to understand what's the issue.
So it's difficult to explain, given the religious nature of the explanation. And I'm not sure, Jeff, help me out here. It's different if you attest to something than it is if you affirmatively put it in writing out there. And I can't explain it particularly well.
I'm going to go to Senator Jackson.
So look, my question is essentially what Senator Sidnor asked. We spent. I'm not going to the bathroom. So I spent. My induction to the Senate was bloodletting, grueling to put things that my career that I've lived, and I came to grips with that. And let me tell you something. I'm a Catholic boy. My mom couldn't afford to put us in Catholic school because my father wasn't worth the name he was born with. However, my grandkids are in Catholic school, and if there are rules that we're supposed to be abiding by, then they should be codified or put in policy or whatever. I'm just wondering why I can attest to this, but I can't. I mean, we put in the police reform bill that we will have civilians that are on the board to swear and affirm that they don't have any connection with something, you know what I mean? And we're not going to require that here? I'd just like to know why.
Okay, yes, Senator West.
Thank you, Mr. Chair. Can somebody just in some way satisfy my concern that if we pass this bill, we will be requiring private schools to enroll students irrespective of their disability? So if someone has serious dyslexia and the school has no program to deal with dyslexia, I can't see requiring a school that has no dyslexia program to enroll a student who is dyslexic. So if you can convince me that this bill doesn't contain that requirement, I think I'm good with it.
Okay, so we talked about the. Yeah, well, we're about to adopt it in a second, but so now we're back to the. Unless council wants to chime in here, but the reason you're talking about just the reasonable accommodation, and if they can't, then there's. You're basically worried about the accommodation, and if they can't accommodate someone with a disability.
Where is it? Hold it. I'll find it. County shall. Where is it? Who knows where this language is? About accommodation. Oh, it's under the discrimination section. Wait a minute. God damn. No. Ah. There it is. I'm sorry, it's on page 4, down the middle of the page, lines 16 through 19. So let's assume someone applies to a private school on behalf of their daughter, and she has serious dyslexia, and the school doesn't have a program for dyslexics. This language says, with respect to discrimination on the basis of disability, a non-private pre-kindergarten program or non-public school that provides a student with a reasonable accommodation under federal law. What does that mean?
Yeah. Sorry, council's pulling it up right now.
Is the paragraph on entering into an agreement or taking the action. So deleting you got one, you got one paragraph for one religious sect and the other paragraph for the other religious sect. So it's a free exercise.
Yes, so, all right, on page 4.
Yes.
Lines 16 to 19, it provides that, that the subtitle doesn't apply to discrimination on the basis of disability in any non-public school, so long as the student is provided with, quote, a reasonable accommodation under federal law. So, in the case of a private school that acknowledges that they simply do not have the resources to educate dyslexic children, how does this language apply to such a school? Well, yeah, and I want to know what. So someone applies on behalf of their daughter, seriously dyslexic. The school says we can't educate children with that problem. And the parent points to this language and says, all right. And then the question is, what right does the parent have to make a demand on the school? And what does the school have to do under the circumstances? just if I could throw out an idea, we could say that is not able to provide a student with a reasonable accommodation. That would take that school out of the application of the subtitle. That would seem to me to work. And if the school says, look, we don't have teachers that can teach dyslexics, we can't do it, then the school could say, we're not able to provide a student with a reasonable accommodation under the circumstances, and the parents would not have a cause of action against the school for violating this statute.
See, I think that's already a case because there's we're looking at it now, but there's an not an escape valve, but basically, if you can't provide it, then it kind of absolves you of that liability.
Well,
As long as you've attempted to do it, and if you can't, then there's...
Anything could be provided. The school could hire 8 teachers for history, math, et cetera, all of whom are able to teach dyslexics.
No, I get what you're saying. Anything was in the realm of possibility, I guess, I
Yeah,
suppose.
right.
But what I'm saying is I've seen it before, and I just can't recall it. I think we're looking for it now, but it provides for the justification for not being able to address that.
Okay, let me try to find it.
Okay, so currently the ADA does not apply to religious schools. So the ADA covers private elementary and secondary schools as places of public accommodation, i.e. the school must be physically accessible to those with disabilities. But these schools are not required to provide free appropriate education or develop individualized educational programs for students with disabilities. Any private school that receives federal grant monies or any type of federal assistance would then fall under the Department of Education's regulations regarding construction and alteration of the private school's structures and buildings where it can be conveniently and economically incorporated. So if a private religious school receives federal funding, Section 504 of the Rehabilitation Act of 1973 protects a child from discrimination on the basis of disability. However, the ADA contains an exemption for religious institutions, including religious schools. Therefore, the ADA does not apply to religious schools or offer students attending these schools protection from discrimination. And then if you scroll down further at the bottom of the email, it goes over some things that are reasonable accommodation include modification of an application and testing, allowing student to tape record or videotape lectures or classes, modification of class schedules, extra time allotted between classes, note takers, interpreters, readers, specialized computer equipment, special education. An accommodation also includes physical changes to an education institution's building, including installing accessible doorknobs and hardware, installing grab bars in bathrooms, increasing maneuverability in bathrooms for wheelchairs, installing sinks and hand dryers within reach, and so on. Public accommodation is not required if a particular aid or service would result in either fundamental alteration of the services offered by the facility or if the accommodation would impose an undue burden. Under the Supreme Court's interpretation, Congress intended that undue burden and hardship must be determined on a case-by-case basis.
But, we're suggesting that a private school might be required to install elevators, install ramps, provide extra time between classes, so modify the class schedules, all to accommodate a single individual who has dyslexia, when the individual could go to another school which specializes in teaching dyslexic kids. I just think is unreasonable. If that's what this bill provides, I can't support it.
All right, keep going. Senator Castley, you want to explain the second half of your amendment, please?
Sure. So just amending my amendment because a lot of my amendment's been rendered irrelevant by the amendment that we just adopted. So if you're looking at 17.857 8/1, Amendment number 1, just strike what says amendment number 1 because that's no longer relevant. On amendment number 2, the first 2 lines, it says on page 3, in line 16, and page 5, line 1, each instance, strike person, institute, student. That strikes that from the amendment because that's already in the amendment from the House. So my amendment would be that portion of amendment number 2 that begins with on page 4 in line 16, strike enroll and substitute, and then the all the way down to the end. And so what this amendment does is it puts in one paragraph and takes out another. The paragraph it puts in says that this subtitle does not require a non-public pre-kindergarten program or non-public school to, and then this language, enter into any agreement or take any action that inhibits the free exercise of religious rights of the non-public pre-kindergarten program or non-public school as a condition precedent to applying for or receiving state funds. That's the paragraph to go in, and the paragraph to go out is all the way, the last paragraph in the bill, which is currently 26705, which is a paragraph that says, each non-public pre-kindergarten program that receives state funds and non-public primary or secondary school that receives state funds shall develop and maintain a written anti-discrimination policy that prohibits discrimination as described under section 26703 of this subtitle. So, first paragraph in, the second paragraph out. That's my motion.
What we're doing here, does everyone have greater clarity? Were there questions before? Okay. Okay, so there's a motion on the table.
Second.
It's been seconded. Further discussion?
Look, I just, if we're convinced, I mean, we're not supposed to be, you know, we're working on uniformity, we're working on non-discriminatory policy. I think we're supposed to be responsible on these things. And for us to allow one entity to not conform, I'm trying to understand that. And we just went through, you know, I don't think I have to relive the last month, but I just have a concern, so.
I have a question for Senator Cassidy. Would you bifurcate that? So can we vote on the amendments, those paragraphs separately? Because they encompass 2 separate concepts in my mind.
But it seems to me that it's a compromise. You got 2 big groups of people who said, we'll both back each other up, and here's our amendments, and they're working together. And if we want to screw one group of people, let's just screw them both, because they're standing together. The people that asked for each of these paragraphs are working in concert. They propose this as a joint amendment. They want them both together. They concerned about different issues. So to me, we either, you know, bifurcating their mutual support for each other would not be something
Okay.
we ought to do.
So I might have stepped out when you discussed the first part.
Sure.
The no agreement part. Who asked for that amendment, and what is their policy concerning
Sure. So you get the Catholic Conference asked for the first one, which is enter into any agreement or take any action that inhibits the free exercise. And they did it with the both they and my understanding is both they and the Orthodox agreement want that paragraph. The second paragraph, that was just the Orthodox community wanted that one.
Follow-up. Do you believe that the first paragraph covers the current boost attestation? Is that an agreement under the first paragraph you've indicated?
I'm sorry, is the first paragraph what?
So under the first paragraph you've talked about not entering into any agreement
Right.
that's contrary to their religious freedoms under the
Exercise,
First
right.
Amendment, is the attestation that they're currently required to sign under boost an agreement for the purposes of that section that you're trying to add? That's what I'm trying to understand.
Yeah, they don't have any problem signing the attestation, but the current, my understanding is that the current attestation is in line with this paragraph we're inserting, and they don't have any problem signing an attestation with with that language in it. It's the idea of developing their own school policy that says this is our policy. It's one thing to say the state says we're following what the state says we have to do, versus to say, this is our policy.
I'm with you 100% on that.
Okay.
That's the second part of the
Okay.
amendment. What I'm nervous about is that the first part of the amendment nullifies the current attestations. And it doesn't sound like that's what your intention is to do.
How do you think it nullifies the current attestation?
Because the attestation could be viewed as an agreement between the state and the religious school for the purposes of the amendment that you're trying to offer. You're saying,
Yeah, but if it's an agreement that does not inhibit the free exercise of religious rights or in the schools. I mean, the attestation, the intent that we've always put these things on the floor for the budget amendments, the intent has always been that we're not trying to inhibit the free exercise of religion. That's always been the case.
So why don't you just, Jeff, what about just enshrine the current boost language instead of? Yeah, why don't you, can you read the current language for the boost requirements?
Yeah, so this language is from Chapter 19 of 2020. It's the boost language. Nothing herein shall require any school or institution to adopt any rule, regulation, or policy that conflicts with its religious or moral teachings.
How's this different than Bob's amendment?
I mean, I guess ours is a little bit weaker because it talks about the free exercise of religious rights, but, I mean, we're talking, in the one, the language is, inhibits the free exercise of religious rights so it's free exercise of religious rights versus religious teachings, right? I mean, we're kind of similar.
I'd say the difference is as a condition precedent for applying or receiving state funds.
I mean, yours says the religious teachings, what was it again?
It says, nothing herein shall require any school or institution to adopt any rule, regulation, or policy that conflicts with its religious or moral teachings.
To the vice chair, what do you, I don't understand, what is giving you trouble between the current language and what the boost? I don't understand the big difference. Yeah.
okay, sorry. I'm worried that the attestation, I'm fine with the second part. They don't want to put it in their policy.
No, I understand that,
But
but
as part of Boost, they have to create this attestation under current law. And I'm worried that the first part of Senator Cassidy's amendment will void the attestation itself as being an agreement that infringes upon their
No,
religious
I understand that, but when she read off the current language.
I'm
for-
fine with the current language. If you
But
want to,
what is to you, I don't understand, what is functionally different between Cassie's language and this?
right, so it's the reference to an agreement between the two parties. I'll ride with you. If you want to substitute the current law, I'll ride with you guys on the amendment.
Can we hold it just for the next one, and we'll run that language by, I mean, I don't want to sit here and fight over something, and then people say, that's fine too, right? Can we do that? Can you send me that language, please? And, okay, so we'll just hold this amendment.
Bob's negotiating with.
I know, this is great, All right, so let's do this. How about, can Senator Wallstreicher, Hedelman, Castley, and West get together on this?
Yeah, I mean,
Okay.
I may be in agreement here by tomorrow, so I don't know, I just.
Got it. No, I hear you.
I didn't write either one of these, so I'm.
Can you forward that to me as well?
Yeah,
boost. All right. So hold it. Okay, Senate Bill 455.
What one did we go to? 455. 455. Okay, this is an easy one. Okay, so Senate Bill 455. This bill increases from within 6 months to within 300 days the time for filing a complaint with the Maryland Commission on Civil Rights that alleges an unlawful employment practice other than harassment after the date on which the alleged discriminatory act. Complaint filed with a federal human relations commission within 6 months or a local human relations commission within 300 days must be deemed to have been complied with the requirements. The commission was favorable with this because federal law with respect to employment discrimination prevents or permits an aggrieved party to file a complaint of alleged unlawful discrimination with the EEOC within 300 days of the alleged unlawful act. Amending the state law to conform with the federal law will ensure that Marylanders who believe that they are victims of unlawful employment discrimination have equal access to MCCR as they currently enjoy with EEOC, and that's what the commission said.
Discussions, Senator Carter.
Thanks, Heather. I apologize because I know you read the amendment, but I just want to make sure. So all that you did is ensure that the local entities that do similar work to the Maryland Commission also extend to every 300 days, right?
There's no amendment, is there?
Oh, that's not an amendment? It's just, oh, she did, I thought she was reading an amendment. She was reading the bill.
Yes.
Saying the purpose for the bill.
So, but we have Maryland Commission, but then we also have like, you know, Howard County Commission, you have Baltimore City, so you have the locals, so it would extend to all of them, right?
That's fine. Yeah, it just makes it the same as what's already federal law for EEOC. I had this bill once upon a time, Senator Sidnor. Congratulations on getting it across the finish line.
Not a sponsor problem.
Yeah, I had a sponsor problem back then, I guess. All right.
To Senator Carter, yes, that appears on the bill, page 2, lines 15 through 18, for the local question.
Motion, further discussion? Senator Cassidy.
Obviously, I can see what it does, but was there a reason? I mean, other than just let's extend the time, was there something? I'm sorry. Go ahead.
And I've cross-filed this on behalf of Delegate Hill, and she had a constituent who ran into this issue and was unable to move forward. So I think that was the impetus behind this.
And I didn't see much in the way of opposition. Was there? It's just that one chamber.
Yes,
It was a
there
local
Just the chamber.
One unfavorable is saying that 182 days is enough time in
Yeah.
the current law.
Okay. Are there any, counsel, do you see any downsides to, I'm trying to.
It creates uniformity between the EEOC and commission, and there's already a work share agreement, so having the same timeline, I think,
Is more
would make
convenient.
sense.
It makes sense then.
That's what I think. Like if federal was 180 days, I think it would make sense that the state's the same, but if federal's 300 and there's the work
then
share
ours should be 300
agreement.
also. That makes sense to me. Okay, thank you.
That's the question, why didn't the EEOC instead of MCCR? But whatever. All right, so motion for a favorable. Seconded by Senator Sidner. Is everyone okay? All right. Senator West, Senate Bill 494. Actually, I'm sorry. Let's we're going to skip on this for now. We'll come back to it. Let's keep going with Senator Lee, Senate Bill 527.
This bill alters provisions governing probation before judgment by, 1, authorizing a court to place a defendant on probation before judgment if the court finds facts justifying a finding of guilt, 2, repealing the requirement that the required written consent of the defendant to the probation before judgment occur after a determination of guilt or acceptance of a nolo contendere plea, and 3, clarifying that a court may suspend a portion or all of a sentence imposed for a probation before judgment. You have one amendment in your packet. That is number 983323/1. And what this amendment essentially does is it creates entirely new provisions in the probation before judgment statute for this type of facts justifying a finding of guilt probation before judgment. And those provisions make it clear that the defendant in those cases is waiving the right to trial and appeal. So you also should have in your packet a advice letter from the Attorney General, who had flagged some concerns with the version of this bill that passed last year, and discussing some of the potential constitutional issues with this year's bill, with the amendments.
Letter here. I mean, Susan, does this address the judiciary? They kind of have a scathing letter in here too.
Yeah, Michael, the reason why we did the amendments was to address some of the judiciary concerns. So what this is doing, it's creating like something akin to a no-low contender. Sorry. Yeah, the reason why we did the amendments was to clarify things and address some of the concerns the judiciary had. So what it does, it creates like something akin to a no-low contender, where the concerns of the constitutional issues I think were addressed already, and it's similar to what passed in Virginia and New York. They changed their probation statutes to avoid what is essentially an injustice. And they have not, since they passed it, had any concerns, constitutional concerns. So, well, the plea of NOLO is just like a plea of guilty. It has the effect of submitting the accused to punishment by a court still. And but it corrects an injustice. You heard the example of the woman who was a veteran. She had served in the U.S. Army for 31 years. She had a charge where she was using painkillers, and she had a PBJ, but then when she went to get her citizenship, she found out that she was going to be subject to a deportation because under the federal law, even though a PBJ in Maryland law is not considered a conviction, the purpose, it is considered for federal immigration purposes. And that's why Virginia and New York and some others have passed laws to correct their probation laws so that it would avoid injustices like this.
Thank you, Mr. Chair, and thank you, Senator Lee. I just had a couple of questions, and I want to make sure that I 100% understand the bill and the bill with amendments. So, my understanding of the bill as it came in is it simply would allow for a court to decide that a probation before judgment could be entered without the prerequisite of a guilty finding, right? And that was the goal of the bill. With the amendments, it sounds like, and I'm sorry, I didn't print them out. The amendments, it sounds like the amendments just say that just like currently when a PBJ is entered, a court, a defendant must waive the right to appeal because there's no technical guilty finding from which to appeal. So that's all the amendments do? Or counsel?
Yeah, counsel, can you?
Yeah, so the concern that was raised last year is exactly as you're saying. Because there was no formal guilty finding, there was a concern that there was nothing to waive, and therefore someone wouldn't waive their rights, and that it created a potential due process problem where, similar to how it was before the PBJ statute was enacted, where courts would simply put someone on probation without any kind of guilty finding, and that was found to be constitutionally deficient. So there was, I think the idea of the amendments, I'll let Senator Lee explain a little further, but was to essentially make this a lot like a no-low plea, where a no-low plea is also not exactly a finding of guilt, but it still allows you to do a PBJ. So the idea was to basically make this more similar to the no-low plea than the old probation without conviction, which was constitutionally deficient. And the Attorney General, I think, lays out the issues far better than I could, but it's not entirely clear that it does that, but there seem to be arguments on both sides of that.
Also, I don't want ever to be taken away from me and a million criminal defendants the idea that I don't know that it's recognized anywhere in statute, but what happens in district court is not a guilty plea at all or a no-low contender. It's a not guilty agreed statement of facts. And this doesn't affect that at all. It would just, like, where that exists, it would still be able to exist. It just would not have the prerequisite of a conviction as the basis upon which a PBJ is entered. That's all that we're doing.
Correct.
However we get there, the final result is that.
Correct, yeah, the amended bill is basically splitting this out into its own statutory provision, and the idea is not to affect anything that currently happens in court.
And there's still the option. The court can enter the guilty finding PBJ or say, I'm not entering a guilty finding PBJ.
If that is, yeah, what the court is currently doing, the bill should not affect that, no.
Okay, thanks.
All right, so let's move the amendments, so at least we can work off of that. Everyone's okay with doing that? So, we could do, Senator Cassidy, you can go ahead. We'll do a roll call on the amendment, but go ahead. You want to do a roll call on the amendment?
Yeah.
Okay.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Cassidy.
No.
Senator Heddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
No.
Senator Carter.
Yes.
Senator Huff.
No.
Chairman Smith.
Yes.
All right, further discussion.
Yeah, could someone now explain how this amendment responded either completely or partially to the concern expressed by the judiciary? If I can find it.
Yeah, so as I understand it, the concern expressed by the judiciary was essentially that without these clarifications about the procedure, what the bill was doing was essentially replicating the old scheme before this statute existed, where a judge would simply place someone on probation without any kind of finding at all. And because of that, it was not clear that, that you could waive your right to appeal or trial, because it was not clear that there was any particular finding to appeal. So I think the idea was to make it very clear that when you do this, that you are waiving your right to trial and appeal.
Okay, so the working assumption here is that with this amendment, we've satisfied the judiciary, right?
My understanding is that the judiciary has received the AG's letter today, and they're still considering whether that changes their position or not. I don't think they've reached a final decision on that.
Should we hold this till the next voting session to see if the judiciary gets back to us and says they're copacetic with it?
I thought I received something today. Just give me a second here.
Okay.
All right, so I did get something from the judiciary. Okay, so this is from the judiciary. Thank you for the email. As we indicated yesterday, the judiciary's letters of committee will review the bill amendments and the OAG letter
of advice tomorrow. Our position, however, is unlikely to change, particularly given the OAG letter, which notes due process and enforcement concerns. The due process concerns, which are constitutional in nature, are the same concerns we expressed. As such, all preliminary indicators that we will remain opposed. So that was at 3 o'clock today. Have you received anything further from them?
Reviewed it completely yet, right?
We're going to hold it just to the end
Okay,
of the
let's
calendar
hold
here.
it.
I'm going to check, get somebody to check with them right now, so we can get a solid, more solid answer. Okay.
Okay, we'll hold it.
If not, we'll put it up for a vote soon.
Or put it for a vote. You want to put it for a vote?
After, I'm going to loop back with them right
What's
now.
that?
I'm going to loop back with them right now.
Okay.
Just put it at the end of the day today. Okay. Kelly O'Connor on the phone.
Senate Bill 581, Action for Change of Name, Waiver of Publication Requirement. This bill requires a court on motion by an individual who has filed an action for change of name under Maryland Rule 15-901 to waive the publication requirement set forth in the rule. Currently under the rule, unless the court on motion of the petitioner orders otherwise, the notice must be published one time in a newspaper of general circulation as specified. There are no amendments.
Senator Hellman?
Motion for favorable?
Senator Castley?
It says that the court shall waive. That's unusual that we would tell the court did the judiciary weigh in on that? Because in the past, to remove all discretion and say, you're just here to make findings, and once you make those findings, we're going to dictate to you the result. They've pushed back strenuously. So it seems to me that it ought to say the court may, I'm sure the court will probably grant it, but we ought to give them the discretion.
Oh, so the judiciary did weigh in on this. They submitted a letter of opposition. In summary, the judiciary traditionally opposes legislation that includes a mandatory provision and takes away judicial discretion. The judiciary believes it is important for judges to weigh the facts and circumstances for each individual case. Provisions that place restrictions on the judge prevent the judge from considering legislative intent or factors unique to the case. And that's from the judiciary's opposition letter.
So the judiciary now has the ability, and in some jurisdictions it is pro forma and they automatically waive, but in other jurisdictions they don't. And it has become a real problem. And so that is the reason for the bill, is because there is such wide variation among different jurisdictions. And this
But don't you think the reason that there was a wide variation is because a lot of judges said, look at the law and say, I have no power to do this. The law says publish. And some judges said, well, I'll just not follow the law. And a lot of judges would say, well, I'm going to follow the law. So now you give them an option. You say, the law now gives you this power, review the case, and you may do this.
It doesn't change anything about the process other than the publication process. There's nothing that changes except having to go to the newspaper and pay the fee and run the ad. It's antiquated and it is harmful in some instances. And so that's why. The process is still the same. The name change process is still exactly the same. It's just the publication.
So just a question, and maybe for Senator Castley, or I don't know, somebody who does this, there's got to be a legal reason why you want these published. What is is it for debt collectors, or for what is the legal reason that? Can you turn his mic on? I can't hear him.
I'm sorry. It's for anybody who's looking for anybody. That's why if you go to we all get the daily record here every day. It's full of notices. In a lot of cases, these are notices of name changes and the like, estates opening. All these things are there are people who actually read that part of the daily record, and they go through looking for people and issues. So the intent is that if I'm trying to escape from my creditors or escape from my marriage or escape from any legal obligation, that there's a public notice out there that says, hey, here's this guy and he's changing his name. I mean, there's currently provisions of the law that exceptions to that if I'm changing my name because, the mob is after me or certain things that allow the court to consider it. But in each case, the court considers it, and the court can say, this is, I don't believe you, or I find that your reasons for trying not to publish this seem nefarious or whatever. So that's why you don't usually just say, hey, court, you're here to find facts. We never do that. We never say, court, you're here to find facts, and you have absolutely no discretion with what to do once you find the facts. The courts always push back, and we always agree that it would be a power that they have the discretion to use, and if they don't, then they don't. So.
I mean, it's just so, and I'm looking at the bill. I mean, it doesn't. I know that we had one group of individuals come in and express why they didn't want it in there, but this is for everyone. So this is everyone can get by this. There seems to be a legal reason why you would want these filed. And then we're not taking any amendments to address the judiciary's opposition and taking away judicial discretion on this.
Reason. First, this goes back to a day before there was the internet, right? This goes to a day where you had a publication and newspapers and people went through them, like you say. Now, everything's online. You can still get this information. Debtors are still going to have the information.
Where would I find it?
It's all in case search. It is all anybody who's after anybody
Hold on. Let me back up. So you're saying it would be that if I go into case search, the case will be up there and it shows their previous name and their current name?
Correct.
But how would I know to search when I search somebody in case search? I guess I search under their old name.
And it will be linked to their new name.
Do you have an example of that? I just want to make sure that if I search them, it comes up like that versus it comes up a new name.
So if our objective here is to say that this is an antiquated process that should be removed, then let's introduce that bill and say nobody has to do this. But the difference between public notice, public publication, and searching the internet is the publication says this is happening now. Hey, everybody, anybody, people looking at the paper say, hey, look what he's doing, or look what she's doing. That's a change now. But if we're going to say that this doesn't need to be done, which is the argument that's being made, that this doesn't make any sense anymore, then the worst law of all would be one to say to the courts, everybody who wants to file one of these can, and you have to grant them all, which is a terrible way to make the law. If we truly believe this is antiquated and shouldn't and is no longer necessary, we should introduce legislation that says this is antiquated, nobody needs to do this, have the hearing on it. If everybody who comes in who's normally interested tells us, no, you're right, none of us rely upon this stuff anymore, this is all antiquated, then we stop doing that. But to say, well, we think this is antiquated, but instead of repealing that, we're just going to have everybody file a motion with the court, and then they'll have to grant it anyway. This doesn't seem to make any sense to me.
We're giving the discretion to the judge about whether to grant the name change. That's the point of the process. So the judge has that total discretion. This is just about publication of the name in a periodical. That's what it is. So the judge maintains the discretion about whether the validity and the accuracy about the name change. There is, I'm sorry, go ahead.
Is there a second?
Second.
It's been seconded. We'll run it. Roll call.
Vice Chair Waldstraker.
Yes.
Senator Lee.
This is favorable, right?
Yes.
Yes.
Senator Castley.
No.
Senator Hedelman.
Yes.
Senator West.
Pass.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey,
No.
Senator Carter,
Yes.
Senator Huff,
No.
Senator West,
Yes.
Chairman Smith.
Yes.
Last. All right, let's move on to Senate Bill 669 and 670.
So these are two bills, but they tie in together. The bills prohibit a party in a civil action from requesting a jury trial if the amount in controversy does not exceed $30,000, exclusive of attorney's fees, if attorney's fees are recoverable by law or contract. Currently, the District Court of Maryland has exclusive original jurisdiction for a civil case in which the amount in controversy does not exceed $5,000. The Circuit Court has exclusive jurisdiction in a civil case in which the amount in controversy does not exceed $30,000. So the District Court has concurrent jurisdiction with the Circuit Court in a civil case in which the amount in controversy exceeds $5,000 but does not exceed $30,000. So a plaintiff can file in any court currently, or if the plaintiff files in District Court, either party may demand a jury trial. And if that happens, the case then is moved to the Circuit Court. There is an amendment in your packet. It's the same for both of the bills, the bill and the constitutional amendment, which decreases the amount in controversy in the bill from the $30,000 amount to $20,000.
Senator West.
Thank you, Mr. Chair. So the last time the amount was increased to its current amount was about 12 years ago, and I took a look at what the inflation is in the aggregate for the past 12 years, and it's somewhere a little higher than 20%. So this proposal is to literally double the amount of the amount at issue from $15,000 to $30,000. So my amendment would increase it by a third, but not by 100%. And let me explain why. I got two reasons why. Number one, I passed out there is some evidence that after the last increase, insurance premiums have risen. I'm sure people will argue that there were other reasons why they went up, but I just called to everybody's attention. And, you know, perfectly frankly, since the trial lawyers are sponsoring this, they wouldn't be sponsoring this if they didn't expect to get higher judgments in their cases as a result of this. And if there are higher judgments, excuse me? What? Of course I can say that. And if the judgments go up, of course insurance premiums are going to go up because the system is money in, money out. So that's one thing. Secondly, I got an email, I can't find it, from a consumer protection organization that said that effectively that it's not just people in car accidents that go into court. And so this would essentially take away from consumers, from small people who don't have lots of incomes but have cases, they would take away their right to a jury trial. If they're defendants in a case, they would no longer have the right to ask for a jury trial, up to $30,000. And many people, the cases they have in court aren't $30,000 cases. They're lower than that. So for both of those reasons, I think that the proposal here to increase it from $15,000 to $20,000 makes sense, and I support the amendments.
Thank you, Mr. Chairman. I'd urge the committee to reject the amendments. First of all, I'm the sponsor of the bill. I am not a trial lawyer. I'm a defense attorney, and so this bill doesn't benefit me, that's for sure. The second thing is that it's inappropriate to use the CPI as the adjuster here. Most of the cases to which we're referring have medical costs associated with it. And we know that medical inflation is an entirely different thing than consumer inflation. So what you pay for a box of widgets at Amazon is not relevant. What you pay or what you're billed when you go to the hospital for severe bodily injury is very much relevant. And we know that medical inflation has far exceeded consumer inflation, and that's why the number goes up so high. last thing, we did get an email from someone claiming to advocate on behalf of people who are victims of wage theft. And the senator referred to this letter. I just want to be clear, most people who allege wage theft are on the bottom edge of the wage spectrum. People making minimum wage, folks in construction. And that type of wage theft, so $15,000 is the current limit. If someone were making minimum wage, then their claim above $15,000 would be like 100% of their income. So it's just not accurate that wage theft needs juries. In fact, most victims of wage theft don't even go to trial. Instead, they use the administrative process at the Department of Labor, which is completely set up to deal with claims like that. And what that shows you is that victims of wage theft not only don't want a jury, they don't want a trial, they want their wages as fast as possible with the least amount of burden as possible. That's more of an argument for the bill than it is against the bill. So I'd urge a rejection of the amendment.
All right, Senator Cassidy, and then we've got an amendment on the table. Go ahead.
So our current threshold is 15,000, which was the second highest in the country, only to Louisiana's. But in 2020, Louisiana changed theirs from 50,000 down to 10. So currently at 15, we lead the nation in the highest threshold for a jury trial, and we're looking at doubling that threshold, being the outlier that we are. I do a lot of small claim stuff, small people. To them, 15 grand is a lot of money, 20 grand is a lot of money, 30 grand is a lot of money. And I realize that the whole district court becomes sort of consumed by the automobile accidents, because that's just what we do in society, is crash our cars. I think on the issue of the medical cost inflation, I mean, look, generally in the district court, the medical costs have to do with physical therapy. These are not advanced life-saving treatments. If you got that, you're in circuit court, because your medicals are 50, 100 grand, 200 grand pretty quickly for serious stuff. So the district court, if you're even thinking about suing in the 30 and below range, you're looking pretty much at soft tissue with some ice packs, stimulation, some massage, and not people where you're talking about open heart surgery and major trauma, people having to be flown from the accident scene. So we did get the American Property Casualty Association chart that does show, and we've seen this in past years, so we all know this. It does inflate our insurance premiums. That's just the way it goes. You do these kind of things, you inflate the insurance premiums. So I think I would support the amendment, but I don't even support the bill, though. So the amendment's a step in the right direction, but I don't see a reason to move it up at this time, because we didn't change it very long ago. Thank you.
All right, this amendment before the committee. It has not been seconded. All right, it's been seconded. Okay. So it looks like we're good. We'll roll call. Let's do.
Vice
No.
Chair Waldstreicher.
No.
Senator Lee.
No.
Senator Cassidy.
Yes.
Senator Heddleman.
No.
Senator West.
Yes.
Senator Sidnor.
No.
Senator Jackson.
No.
Senator Bailey.
No.
Senator Carter.
No.
Senator Huff.
No.
Chairman Smith.
No. All right, further discussion.
Thank you, Mr. Chairman. I move the bill.
So motion for favorable, seconded. I'll second. Let's do a roll call.
Do you want this to be for both bills or?
Absolutely correct. So it's a motion for favorable for both bills, the bill and the constitutional amendment.
Vice Chair Waldstraker.
Yes.
Senator Lee.
Yes.
Senator Castley.
Pushing back against the god-awful power of the trial lawyers and the teachers, and the teachers' unions, I vote no.
Senator Heddleman.
No.
I'm sorry.
No.
No. Senator West.
You said no? Whoa. No.
Senator Stignar.
Yes. Yes.
Okay. Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
Yes.
Chairman Smith.
Yes. All right. The bill passes. Bills pass. Both bills. Okay. We'll go on to, Heather, you ready? Senate Bill 686.
Condominiums, HOAs, and cooperatives, virtual meetings. So this bill generally permits the applicable governing body for a co-op, condo, or HOA to authorize any meeting to be conducted or attended by telephone conference, video conference, or similar electronic means, subject to specific standards. The bill also addresses the use of such electronic means for meetings, quorums, and voting purposes, and the inability for an individual to attend due to technical difficulties. And it also establishes that floor nominations are generally not required if at least one candidate has been nominated to fill each open position on a board of governing body. There are no amendments.
Senator Sidnor.
Thank you. I do have, I think this is probably the second bill that seems to try to address what's been going on now. I'm wondering, are there any business entities that can no longer have virtual meetings? Or, I mean, have we captured them all?
That I do not know. All I know, I mean, look, I just know what the testimony was for this bill is that a silver lining and through the pandemic is that when you have these virtual meetings, you'll have a lot more greater participation and more transparency.
Oh no, and I'm not.
No, I get it. No, I don't know. I don't know the
I'm
answer
just
to your
wondering
question.
if it. I mean,
We should
if
we should do some
missed
study though. We should seriously. That sounds like a good research question, honestly. And we still have some vehicles, in the drawer here.
And that's all I'm asking, because I'm thinking as we're doing this, we should just make certain that they all have this ability.
No,
that's all.
I got it. We still have vehicles in the committee, so if you find anything in research, you can figure something out.
I think I did a bill in some past year that lets corporations, LLCs, REITs, et cetera, have virtual meetings. So, but you're right. If there is anybody we've left out, we got to find out who it is and add them.
No. Yeah. Is everyone okay? All right. Everyone's good. Bill passes. All right. We'll go down to Senate Bill 691, and then we'll come back to 671. Senator Hellman.
So this is a bill on the reusable tenant screening report. So it requires a reusable screening report to contain certain information regarding a potential tenant. It requires a notice regarding whether a landlord accepts the reusable tenant screening report, and it also prohibits a landlord from charging fees related to the report. There is an amendment in your packet. So this is the amendment that is similar, or the House hasn't passed this yet, but this is the same amendment as the House. There is at least one technical correction that it needs. It's just like in the purpose paragraph. So if you're looking at amendment number 1, the last 2 lines, strike providing that a consumer reporting agency is not civilly liable under certain circumstances. That's not in the bill. That's just left over from a previous version of the amendment.
So this has actually been carefully crafted. There were a number of people who raised some issues during the hearing, including the landlords, MMHA, and including CDIA. And everyone came together, and there is consensus that security issues have been addressed, as well as the information that the landlords need and want for their checks. So this is not required, but it is offered, and it is a service that can be really helpful for tenants.
Well, in that case, I have some issues with it, and the amendments don't seem to address the testimony that I see from PBSA, the Realtors Association, MBIA. So I'd ask if we just hold it until I can double check and see, because I have issues with it. It doesn't seem to address the testimony that came in.
Directly. Because it's only done in one.
Let's hit Senate Bill 671, and then we're going to go to Senator Jackson's 874, okay?
Senate Bill 671 limits the circumstances under which a police officer must charge by citation for specified misdemeanor or local ordinance violations that have an imprisonment penalty of up to 90 days. The bill also expands the offenses for which a police officer may charge by citation to include offenses other than possession of marijuana, possession of a controlled dangerous substance. Lastly, the bill requires that MPTSC, in consultation with the Anne Arundel County Police Academy, develop and maintain a uniform statewide training and certification curriculum that includes role-playing exercises to ensure the use of best practices in the issuance of citations in lieu of arrest. There is one amendment in your voting packet. This is Amendment 643-821/1. That's 643-821/1. And it makes alterations in the criminal procedure article to provisions relating to extradition. And if you turn to the reprint, you can see the changes that are being made relate to an application being made when extradition is sought, and it adds citation stating the incarcerable crime with which the accused is charged needs to be included in the application, and that is just for reference. If you're looking at the reprint just after bill page 404, it's the unnumbered page that follows that.
All right. Further discussion? Do you want to say anything? We're good?
The extradition. I'm looking at the reprint and the. What are we adding in this reprint, Jamie? Which page is the lines? This is confusing.
Thank you. So it is just after, it's the unnumbered page that is just after bill page 404 on the reprint.
So everything on page 404, none of that's actually new? That's not part of the amendment?
Well, after line 11 is where the amendment language starts. And right there, just after line 11 on bill page 404, you've got the existing language from Criminal Procedure Section 9-123, and that pertains to extraditions. So subsection A deals with cases where the person is charged with a crime, hasn't been convicted yet, and extradition is sought. Subsection B pertains to cases where they've been convicted of a crime and they've escaped, broken bail, probation, or parole. This is in the existing law, and extradition is sought. And then if you go subsection C, which is at the very bottom of that page on page 404, provides for what the application would need to include. And this would be, it says that the application shall be verified by affidavit, be executed in duplicate, and be accompanied by 2 certified copies of the indictment, and this is from the existing law, the indictment returned, the information and affidavit filed, the complaint made to the judge or district court commissioner stating the crime with which the accused is charged, and then here's where the new language is coming in. The citation stating the incarcerable crime with which the accused is charged, or the judgment of conviction or the sentence. So that judgment of conviction or sentence is the existing language.
So that's only included because now we're only adding that as clarifying language because now we're doing citations. Is that right? We're not really changing the substantive law? Is that?
Well, yeah, my read of it is that the focus of the bill is to expand offenses which somebody may be charged with by citation. I think just sort of going off of the bill language, you could have the citation for possession of controlled dangerous substance other than marijuana, which could carry a period of incarceration since it's the but right, it could be that the offense that they're charged with requires or they're seeking extradition for it, so you would have a citation, and I think that's what that is, that's getting after.
Can I say, what are you trying to do with your amendment? What are you trying to do with your amendment?
So
it was a simple bill.
Yeah, so it's state's attorney, yes. So tell me if I say this backwards, Jamie, because so state's attorney Riley conditioned the State's Attorneys Association support on this amendment to make clear that if they needed to extradite someone to a border state, meaning in his case Delaware, but obviously in Montgomery County to Virginia or wherever, that they would continue to have that ability even as we extend the citation.
Which is why we put the citations in that provision.
Correct.
Okay, I'm fine then. Thank you. That was easy.
All right, let's go ahead and, is everyone okay with adopting the amendment?
Yes.
All right. Is everyone okay? Motion for favorable, it's been seconded. Is everyone okay? Favorable with amendments. All right, the bill passes as amended. Okay, we're now going to go to Senate Bill 874, Senator Jackson.
So this bill establishes the work group to study partial expungement. The work group is required to study and develop a plan and legislative recommendations for enabling the expungement of criminal charges that are currently not eligible for expungement because of the requirements of 10-107 of the Criminal Procedure Article. That's the unit rule. And then on or before January 5th, 2022, the work group is required to report its plan and legislative recommendations to the General Assembly. There is one amendment in the voting packet. That is Amendment 553-728/1. That's 553-728/1. And What it does is, the bill is drafted provided that the work group would include a representative of the administrative office of the courts appointed by the governor. This instead provides that the AOC representative would be appointed by the chief judge of the Court of Appeals.
Simple, non-controversial.
All right. All right, open for discussion. Senator Weston.
Thanks. I'm sure I should know the answer to this, but is it conceivably a violation of the separation of powers for the General Assembly to enact a statute which requires the judiciary to appoint someone to a work group?
They never even want to serve on work groups. It's also true. There's constitutional issues. Actually, that's good. It's a Jamie question. Every time we try to put the judiciary on a work group, they say they can't constitutionally be on it. With the exception of JRA, somehow they were on that one. But I think that's their excuse. Oh, constitutionally, we can't be on your summer work group. I actually have that same constitutional requirement myself.
I don't believe there was any opposition from the judiciary on this bill.
But they were not on it as it originally came in.
Well, they were on it, but their representative from the courts was originally to be appointed by the governor. So what the amendment does is it changes the appointing authority from the governor to the chief judge of the court.
I know it's odd. You know what? The one that we couldn't get them on was they wouldn't join the well, there might be multiple ones. The task force we had though on the overcrim and all that stuff. The big one that Mary Washington and I have that Jeff's on. They wouldn't. They said constitutionally we can't be on it. I don't know.
I mean, did they give us some case law or some?
They claim whenever there's been about three or
general concept.
Yeah, like 3 or 4 times we tried to put them on task forces, and they say they can't. So I don't know.
The sponsor of the bill on the House side is very much involved with JRA. They requested the amendment. That's why we offered it in committee. So I'm sure they've cleared that. So I think we passed the bill as it is, and if there's a challenge, then we deal with it. I mean, it's the judge. The judge is appointing the administrative officers. One representative from AOC.
Yeah. Well, that's the point of further inquiry, but unless you have a solid answer on that.
No, I just haven't received any information from them.
It's up to you. I'll defer to the. It's not controversial.
It's not. No one's messing with it. I think you might want to check that because I've gotten pushback on that. And you don't want to have to try to amend it on the floor or get caught in conference or something. I don't know.
Senator Jackson, what's your pleasure?
You
hold it for.
We've got like 3 bills at the end of our voting
Okay.
list today. So I'm
just hold it to the end. Okay. If you can get an answer, then.
Yeah.
All right.
I'm going to try to.
Yeah. Sorry. All right. Let's then move on to Senate Bill 775. Is a withdrawal. Is everyone okay with that? All right. Good. Everyone voted to withdraw that. All right. Senate Bill. 911.
So there is an amendment in your packet for this bill. This is unlawful employment practices, statute of limitations, and remedies. So this bill increases from 2 years to 3 years the time within which a person may file a civil action in circuit court after an alleged unlawful employment practice has occurred. The bill also increases from 2 years to 3 years the amount of back pay that may be awarded in such case. The bill had repealed the limitations on the amount of compensatory and punitive damages that may be awarded to a plaintiff in cases of unlawful employment practices. However, the amendment puts the caps back in, and then updates or increases the caps. So the caps range under current law between $50,000 and $300,000 based on the number of employees the employer employs. So the new numbers under the amendment are based on inflation from 2007, which is when the numbers were originally, the current laws from. So
1991.
We talked.
It's 2007.
No. But these caps haven't been raised since 1991. Is what I.
2007.
Okay. Senator Gasly.
In here that the way the bill was the way the law was originally framed, these caps applied to both compensatory and punitive damages. And on page 4, on lines 23 through 26, you've stricken that requirement. So if your intent was to simply upgrade the amounts,
change that.
You've gone substantially beyond that.
Go ahead. Go ahead.
That's a technical error that
Yeah,
we just
that's a
noted.
corrected.
Yeah.
Okay, so you're going to strike those strikeouts?
Yes, that should be struck.
I'll vote for your bill if you're doing that.
No, we did.
Okay. It just doesn't show in the reprint. It doesn't show that those.
I know that's you got an eagle eye, man. No, she mentioned that before, but you caught it. That's good.
I'm sorry.
Yeah, no, you are correct. That should be struck in the
Stricken
amendment.
out,
That was,
okay.
Yeah.
was an error.
Okay, I'm fine then.
Okay. Senator West.
Now, I'm looking at the top of page 3 where the limitation shall increase by $15,000 a year. So the one limitation is to $65,000. That means in 4 years it's going to virtually double. And another 4 years it's going to double again. Another 4 years it's going to. Why are we going to put it on autopilot to keep increasing year after year after year by large amounts?
So we don't have to keep coming back, well, for one, but I modeled it off of what we did with the tort claims. It's the same formula that we did with, I guess,
It's not.
2000.
It's non-economic damages
Non-eco-
under
Yeah.
Section 11-108 of the Court Act.
I think we did that a couple of years. We did that in 2016 or 17. I just modeled it off of that same escalation.
It just seems like a large, for the $65,000 limit, it seems like a large, it's $15,000, which might make sense for the $385,000 limit. But for the $65,000 limit, $15,000 is going to mount up very quickly.
Especially with the Tort Claims Act, those are usually those are the big medicals we were talking about. And these are wage and hour stuff, and you're going from 60, like he says, you can double that real quick. Seems like a heck of an inflator.
Most of these don't.
So,
But
just to clarify so everyone's aware, so the $15,000 is not from the Tort Claims Act. It's from 11-108 of the court's article, which is personal injury action limitation on non-economic damages.
The 15, I'm sorry, the 15
The 15,000, yes.
is from which part?
So, under current law,
Right.
the tort cap increase for $15,000 is from personal injury actions, limitation on non-economic damages, not the Tort Claims Act.
But still, it's for personal injury
Base
action.
that the
Personal
15,
injury, yeah, for tort.
what's the base that the 15,000 is added to?
I asked that earlier today.
But it's considerably higher than $65,000. Why don't we put a percentage in here? Instead of a flat $15,000, which will increase by such and such a percent.
What's your percentage? What's the magic percentage?
I don't know. Come up with a concept, I don't have
I
the
mean,
number.
here's the deal. I mean, it initially was, the bill just removed the caps. And so I thought this is a reasonable kind of level-headed compromise back to earth. But
it's like the way it's set up. Like what Senator West is saying, it removes it for now, but really quickly, it doubles so fast that you're kind of right back where you started from, and that it would be more appropriate, because we're not talking personal injury cases here, or medical stuff, that this would be, CPI or something like that, an inflator. I have no problem with what you've bumped them all up to now. That seems reasonable. But if the inflator was one on the CPI or something like that, as opposed to a 15 grand bump up each time, just seems that in this area of the law, there's an attempt to kind of keep things manageable.
Can't go past 300,000. That's the cap.
Yeah, but most of them are well under that.
Senator West, go ahead.
Throw out the idea of 5% a year. That's considerably higher than the current and the recent rate of inflation. We haven't gone to 5% in a long time.
There's a look. Like we're bumping up the statute of limitations for 3 years. You're also getting 3 years of back pay potential. So we brought the caps up to modern day times and sensibilities. So it hasn't been updated. I thought it was 1991, but you said 2007.
It was 2007. I checked with the commission.
Okay. And so Senator West, you're saying what, 5%?
And it would seem reasonable.
Why is that?
My worry about having a % increase is so every year you must increase by 5%. So in 12 years from now, 5 or 12 years of 5%, that might be a lot more difficult instead of just simply like multiplying it. Like
It's easy to calculate. For next year, it's 1.05 times the amount. The next year, it's times 1.05.
I haven't seen that anywhere in the code before. I'm not saying you can't do it. I haven't seen that done anywhere else in the code.
In court, and you've got people come in their judgments for X, and that's pretty common
In the code?
particularly in district court and enforcing contracts, and the courts are used to.
No, I'm just talking about the code, the Maryland code. I haven't seen percentage increases.
I think it's within the realm of people figuring it out, though.
Look, I'm not actually super opposed to it. I'm looking at, I get what you're saying. For 50 grand, like, I guess, 50 grand for, 15 to 100 employees, you do 15 grand every year. I get what you're saying, that gets pretty high pretty quick. But for the employers that have 500 employees, it's really not that much.
No, frankly, 5% of 385,000 is probably more than
15.
Than 15 a year,
Yeah.
exactly. In fact, it is. 10% would be 38,000.
So then the spread is actually better that way because it impacts the larger corporations that can absorb that cost. All right, let's do this. Can we adopt this amendment, and then we'll entertain Senator West's amendment for 5 instead of just 15 grand escalation? Sound okay? All right. Is everyone okay with that? All right, great. Now, Senator West's amendment, instead of going up 15 grand a year, it's 5% across the board for all employee ranges. Okay. Is everyone okay with that? Excellent. Okay. So now the bill is before you as amended. There are 2 amendments. I'll make a motion for a favorable with amendments. Seconded. Is everyone okay? All right. Great. Senator Jackson, any love on the?
Chairman, we are good. It's the judge appointing someone from the administrative office of the courts. So we're good.
You'll listen to the explanation. It's funny. Have Jamie listen to explain this. On the AOC versus judges, Jamie.
So this is back to Senate Bill 874. The distinction is that in this case, it's actually not a judge that's being appointed. It is a representative of the administrative office of the courts.
And the judge is appointing them.
So they don't have to show up, so they're good now. The constitutional questions are answered.
Yeah, so the judge will pick someone from the administrative offices, so we're good. Thank you.
The amendment is fine as is.
The amendment is fine.
Okay. And the amendment, have we adopted that amendment?
You did.
Okay.
So
Is everyone clear on what the bill does now? It was good. There's a motion for favorable, seconded
Thank
with
you.
amendment. Is everyone okay? All right.
Thank you.
It's favorable with amendments. I said it. I did. Okay. All right, let's just do this. Senator West, Senate Bill 494. Say it again. Sorry. Senate Bill 494.
This bill authorizes a court, when sentencing a minor convicted as an adult, to impose a sentence less than the minimum term required under law. A court is prohibited from imposing a sentence of life without the possibility of parole or release on a minor convicted as an adult. The bill also authorizes an individual who was convicted as an adult for an offense committed when the individual was a minor to file a motion with the court to reduce the duration of the sentence. And finally, the bill establishes related procedures. You should have 3 amendments. Do you want to take them one by one, or should I introduce them all?
Are they sponsor amendments or are they additional amendments? Someone else.
You should have had one amendment in your packet and 2 that were passed out before the voting session on your desks.
Okay, let's do okay, fine. I'll just do my amendments first.
Okay.
And then Senator Jackson will go to Senator Jackson. But go ahead and.
So the first is number 408475/1. So this requires a state's attorney to give notice to victims and victims' representatives that a motion has been filed. It requires that victims and victims' representatives are entitled to a chance to attend and testify at a hearing. It allows the state to introduce evidence during the hearing, and it makes a minor tweak to some of the language in one of the statutory factors, just to clarify its meaning.
I'm moving the amendments. Is everyone okay with adopting those? Sure. So, I'm sorry, go ahead.
Wouldn't they already be able to do under the law? I thought whenever you have these hearings, they already have to send out notice and the state can come in and everything.
So we went over this, and it wasn't clear that the notification had to happen and that they would have an opportunity to furnish like a written statement and actually be there. So that's what. It's just meant to clarify that they have an opportunity to participate.
Okay.
Counsel, am I right? I mean.
Yeah, that's correct. It was a little bit unclear whether this was the type of proceeding that would trigger that. So the language just makes that entirely clear.
Let's go to Senator West and Senator Jackson.
I was going to say the same thing that Josh said.
Yeah, Mr. Chairman, I'd like to amend on to this bill. I served on the JJRC on the House side, and when I came over here, this is part of that result from that. So,
Senator Hedelman as well. Am I on this bill? No, on the bill. I mean, so Senator. Let's just deal with these amendments first. Is everyone clear what the amendments do? Is everyone okay adopting them to work off of? Okay. Additional amendments to add sponsors. We'll do that at the end here, but it's Hedelman, Jackson, Smith, Walsh-Riker, and Lee, right? Did you want to be on this? Okay, never mind. All right. Additional amendments. Are there additional amendments? Senator Cassidy's withdrawing the amendments. Withdrawing your amendments?
Yeah, he's withdrawing.
Okay.
It's a travesty of justice in every way, but if you want to let serial murderers go loose, and that's okay. I mean, this is the absurd session for the Maryland General Assembly.
I mean, I was trying to think this through today, and actually, Senator Cassidy talking about the amendments, and just to listen to some of the crimes that are attached to this, they're just so reprehensible. I just can't even imagine removing life with. I mean, we vote for this. There's no more life without parole for a juvenile. So you got 17-year-old, goes out and brutally murders 6 different people or whatever. There's no more life without parole, correct?
So it's true in a sense, but you can't do it as just kind of an automatic sentence. But you can consider, there's mitigating circumstance you consider. So it's not automatic, but it allows for it's a bar on the straight up, automatic sentence, unless you consider mitigating circumstances, which leaves the door open for the judge to make a consideration over the course of in this bill 20 years. So it's, you can still get life without parole, but this is an option that gives the judges a little bit of flexibility to offer that.
It's not an option. This bill takes it away on the juvenile. You can't give a juvenile life without parole under this bill.
Unless considering mitigating circumstances, right? I mean,
No, you can't give
Miller.
It just says may not impose a sentence of life without parole. I mean, that's the fourth line of the bill. Notwithstanding any provision of law, may not impose a sentence of life without parole.
Difference is, and the disingenuous nature of some of the testimony we get a lot in this committee. This one is one, and then actually there's another bill with life without parole that I'm more amenable to. But the testimony always comes in as disingenuous on that because they forget like half the states don't even offer parole on first-degree murders. This one, what they try to get at is that, my understanding, the Miller case, the one I think it's Louisiana you're discussing, was the judges were doing it, not the juries. So when the judges did it, they whacked it. Said, no, you can't do that anymore. So a bunch of the states, the ones that have repealed this, were ones that were doing it differently than Maryland. Maryland, I thought, was going right to the juries. And so if we do this bill, no matter how heinous the crime is, and they're really bad, the ones that are all in there, you straight up cannot give life without parole to a juvenile. So that means, that means if a 17-year-old kills 6 people, you got to give them, they're up for their first hearing in Maryland, I think in 14 years, 15 with good time. So in 15 years later, you're going to drag the families in now for hearings. So you're basically going from a life sentence to a 15-year potentially out. So, I mean, that's a huge, huge policy change. You shouldn't just gloss this over like it's a minor thing. I mean, and the cases are really horrendous, too. I mean, to be honest, I mean, if you have them with you, Bob should at least read off 1 or 2 of them. They were bad.
There's some of what we're looking at here, and I just go through a few of these. She was 33, Yvonne was 33, her assailant was 17, convicted of first-degree murder. He forced her down an alley. She was raped repeatedly. They didn't have weapons, so stomped her to death with their shoes and beating her and stomping her with their boots. But then she regained consciousness, and he tried to finish her off by breaking her neck, so he had to twist her head back and forth until the breaking sound was heard. But this poor girl was still alive, so he stomped her face with his boot, and then he came back to make sure she was dead, and so he stabbed her and then wrapped her body in plastic and poured bleach all over her. And this goes on and on. You get here's a guy, he's 17, but DNA tied him to 3 murders of 3 women, 37 years old, 34-year-olds, and a 14-year-old kid, all sexually assaulted and strangled. He wouldn't get life without parole. These just go on and on. These are the kind of cases that we're talking about in life without parole. Here's a guy, he's 17, goes into Burger King. They duct taped the man, this 21-year-old kid's mouth, stabbed him, beat him repeatedly, beat him so severely that the duct tape was found inside of his brain, and the assailant said that he didn't care about other people. These go on. So generally, we find people like this, I guess maybe once every 2 years or so in Maryland. Out of the 7 million people, we produce somebody who's 17 and under, who's just this disgusting and callous. Here's this 16-year-old guy. He took this woman, a mother of a 7-year-old. She's only 28, working for her first overnight shift. He slashed her and stabbed her 26 times, and then tried to burn the building down and kill other people. And when she pleaded for her life, he said, "You're dead. That's right. Now you're nothing but a piece of meat." That's what he said to her as he slashed and stabbed her and all that. So I don't know. Some of these, how does just life just? At some point, the crime is just so heinous that these poor victims and their families deserve to know that that person isn't going to come back out on the streets. This isn't the poor kid, the unlucky 17-year-old who his buddies, to be cool, he gets in the back of the car, and next thing he knows, he's involved in a service station, a gas station robbery, and he's like, "Oh crap, I just messed up." And then some numbskull pulls a gun out and shoots some gas station attendant, and next thing you know, he's doing life without parole. That's not happening. That's not happening at all. It's all these disgusting, really heinous cases that we're going to send a message now that says, nope, under no conditions you get life without parole. You get parole after doing 14 years for all that stuff, you too can be potentially back on the street. And the victims and their families, after your 14th year in the DOC, you're going to start having to come down to attend all these hearings every few years so you can tell everybody that you're actually a really good kid now, despite all the lives that you've destroyed forever, and people have nightmares for the rest of their lives. And their lives until the day they die, they start having nightmares about their loved one who, as they recount this thing over and over in their head for the rest of their lives. But you move on with yours. So I just find it reprehensible that we would do this. But
I hear you. And look, I think this is why this is a tough issue, because there is no way to code the crimes that were committed. And you're right, this is a significant policy change. The default sentence then becomes with the possibility of parole, life with the possibility of parole. Can I just finish? Look, it happens every day, and I think that given what we know about developmental science, brain science, given what we know about how people can change over the course of years, given what we know about, part of the correctional system is, yes, one, punitive, but also corrective. And this just offers an opportunity for those that are under the age of 18 to demonstrate that they have rehabilitated and can possibly rejoin society and become productive members. And when that happens in other states, we would have dropped it down to mostly 15 years, and according to some the states that have done this, most of the states are under 15 years. The recidivism rate is extremely low. And so, I think 1%. And so, look, it's a policy call, and I'm not going to sugarcoat it, but this is something that's very significant. So I'm going to kick it off to Senator West, and then we'll come back to Senator Casserly.
Thank you, Mr. Chair. So I guess all we're talking about now at the moment is the fact that the court cannot impose a sentence of life imprisonment without the possibility of parole. We're not talking about the other parts of the bill. So that's third sentence on the top of the page. And what's discussed in terms of the horrible possibility is that a parole board in one of these incredibly heinous cases, what is it, 14 years after the person goes to jail, would actually let the person out? I'd like to get some statistics about how many people who have committed crimes like this have been let out on parole. I know Dave Lumberg, who's the head of the parole board, is a very good friend of mine. I couldn't imagine the parole board letting someone out who committed a crime like that. But this bill is really not about parole. This bill is whether or not such an individual, after 20 years in jail, in other words, he spent more than half of his life in jail, if the crime was committed when he was 17, so he has to be in jail at least 20 years, whether a court determines, when he comes before the court, that the individual is not a danger to the public and that the interests of justice would be better served by a reduced sentence. So that's the standard. And we're letting the same judge who sentenced the person to begin with make this determination, or at least the same court, assuming the judge is retired. I don't have a problem with this. If someone genuinely has rehabilitated and would not be a danger to the public any longer, and the interests of justice would be better served by letting him go, especially in light of the insignificant recidivism statistics that the chair just cited, I have no problem with that.
Reminds me of the 4 years ago or so when Delegate Branch came over and on a bill not too far removed from this, and he said, "You know what, Senator? That's how I used to feel. That's how I used to feel." And then it was my grandson. And, you know, at some point, you got to look and say, these poor there's more than just the killer. There's more than just their life at issue here. And these poor people never get peace. They're going to have nightmares. Just assume that in these heinous crimes were so disgusting, you will never move beyond that for the rest of your life. So if it's a family that's mom and dad and some siblings and aunts and uncles, none of them will ever move beyond this. Their lives are absolutely, they will never reach their fullest achievement in anything. They'll never really enjoy Christmases and holidays. They'll always be thinking about, in the pit of their stomach, the disgusting thing that happened to this young woman. They'll never move beyond that. And all we can think about right now is, hey, maybe he's moved on. But we don't think about they'll never move on. They'll never move on. They'll never have a good night's sleep for the rest of their life. We're so focused on I don't understand this General Assembly anymore, because all we do anymore is focus on the people who are killing us, the people who are murdering us, the people who are killing our kids, who are destroying our community. The focus is on them. Are they doing okay? Did the policeman say please and thank you? Was the policeman a little bit too aggressive? Everything we do here seems to be about making sure that people who want to destroy our society are having a nice day. And in the end, folks, we're killing our communities. We're killing them. We've got little kids who can't walk safely to the corner grocery store, little old ladies who can't take the bus across town safely because we're focused so much on making sure that people who want to destroy people's lives are being treated nicely, are being treated kindly, who can achieve their greatest potential. Guys, you can't run a society like this. You can't run a successful society when you're so preoccupied about making sure that the people who want to destroy your society are having a nice time. We've got to turn this around because we're still on the downslope still. We still have, the murder rate continues to increase. Violent crime is continuing to increase. Look at Prince George's County. This January had 16 murders. Last January, they had 4. 60, that's a 4 times increase just for Prince George's County alone. Baltimore City's on the same track. At some point, folks, we've got to recognize that being the Disneyland parent who's always just making sure people like you isn't the solution to success. And sometimes we got to take tough decisions. We got to tell people, I'm sorry, Junior, but you ain't walking nowhere because you ruined a whole lot of people's lives, and they were good people, damn it, and they didn't deserve to have their lives ruined and their kids taken. And I feel bad for you, but this is real life. And I can't go for a bill like this that just continues to eke this out And when we get prosecutors coming in here and explaining to us how the victims are crying, we used to have Virginia Roper. We burned her out. The victims used to come in here every year and talk about that. But they found that it didn't matter. They had to come in every year, not just once, but every bill every year. And so over the years, we've burned them out. They've just kind of thrown in the towel, and people are becoming forlorn. And I think we're really developing a society right now that's just saying it's out of our hands. We're on a crazy path here, and I can't fathom that this bill, it truly is. I understand people are well-intentioned, but sometimes you just got to do the right damn thing, and that doesn't make you sleep well, and it doesn't make you feel good inside, but you just got to do the right thing because it's the right thing, and this ain't the right thing. Thank you.
Thank you, Mr. Chair. Now, this is an emotional issue, and I can feel your emotionalism about it, Senator Casserly. I just want to say that I wholeheartedly believe that passing this bill is the right thing to do, because we're simply providing an opportunity for people that committed crimes, were convicted of crimes before they were the age of 18. In doing so, Maryland would not be an outlier. We'd be joining 24 other states that have already done this since the Miller decision came out, as well as the District of Columbia. Over the years, this bill is not new. I remember being in the House many years ago and sponsoring it as a House member, and I particularly was moved by testimony from a young man in Baltimore City named Chris Wilson, as well as the other young man that's now like the head of the National Juvenile Reform Movement. Both of them were convicted as children and gave testimony about the ways that they were able to turn their lives around, and it's pretty incredible, and I've said this before. The accomplishments of the one particular person, Chris Wilson, I hope I could live to be 90 years old and I would never be able to achieve some of the accomplishments he achieved. This gives other young people like Chris Wilson that are sentenced as children, assuming they've rehabilitated themselves, they've been rehabilitated, and they're ready to come into society, a chance to come back into society. And finally, I want to say that I recall over the years testimony from some victims' families, and if I needed to, sadly, I don't recall them at the top of, right now, off the top. I could go back and look at old hearings, because there were victims and victims' families that came to testify that said to us that, something terrible happened to my loved one, but I am in favor of this bill. So as horrible as some of these crimes are, there are actually victims and victims' families out there that understand that the tragedy is on all sides. It's what they've lost. It's also the loss of the life and the family of the child that is sentenced. And many times, it's not every family that does not want to see an opportunity for this young person to come back and reenter society. To be quite honest with you, Maryland is late. Maryland is overdue. And I just want to stress that this doesn't guarantee anybody that they're going to come out of prison. Only those that are adjudged appropriate to come out. They're giving it a chance. It's an opportunity. So just as there are those cases, as those heinous situations that I agree with Senator West, not likely they're coming out after 20 years even. But there's also the other situations, like the young men that came before us, the three that the governor released and pardoned, who were not guilty at all. There's those that are not guilty, there's those that are guilty, but we know, and I can speak from personal experience, that I thank God all the time that I am not held accountable for every stupid, ridiculous, asinine decision I made, not only before the age of 18, but by the age of 21 and by the age of 31, and frankly 41. So we're talking about children and people that live to ripen into adulthood being more than the worst act they've ever committed. That's all we're saying. And as that whole person is adjudged by the system, we're giving them an opportunity, as many other states have already done, to have a chance to reenter society if they are appropriate to do so. It's really not, so I just want to stress, it's really not as horrible as I feel like the opponents of this bill are making it out to be. It's really not that bad. If they're not ready to come in society, they're not coming. That's all.
Just say a couple points. So the Miller decision that keeps getting brought up is not analogous to Maryland in that that was dealing with mandatory sentences. In those states, if you committed a first-degree murder, it was mandatory life without parole. And just because we have another bill coming up, that this same argument is made, like half the states, it is mandatory if you do a first-degree murder as an adult, life without parole. There's no other option. And half the states in the country said that for juveniles, too. So this stuff about Miller, all it struck down was mandatory. There's only like 4 states that have completely eradicated and don't have juvenile life without parole kids in there. So this argument that keeps bringing up is not analogous to Maryland. In fact, most states on first-degree murder are much tougher than Maryland. So when Dolores' bill that's going to come in, they're going to make this same argument. I actually think there's a way to work that one out, because I do agree there's some issues there differently. But most of the states, it's mandatory sentences for adults who are first degree. And just to how you look how we got here, the history of what we're doing, it used to be first degree murder in this country, and like in Maryland, in almost every state, capital offense, death penalty, automatic. Life without parole wasn't even created till the 1970s in Maryland, so there was an option other than the death penalty. And now we have all these bills coming in to eradicate and get rid of life without parole for first-degree murders. These aren't just simple mistakes. These are first-degree murders. And to show you the likeness of the bill, what it says, 20 years, second-degree murder in the state is a 40-year penalty. 20 years is half of the time that we put in now for sentencing on a second-degree murder. So, I mean, with that, I would agree with what Senator Castley says, is that the information that is provided to this committee on how we stand other states is incorrect, in that for first-degree murder, we are way more lenient than half of the other states. And to say 20 years isn't even analogous to a second-degree murder in this state.
Speak on the bill before we keep going back to the Senator West, Senator.
Oh, I'm sorry.
No. Okay. Senator Castley.
Yeah, just briefly respond that these cases aren't, I have a tough time with anybody who would suggest life without parole to the shootings that Senator Carter describes. That, it was a robbery gone bad. It was that person's very likely, we would see that they would have a very low recidivism rate at some point. But those aren't these cases. And we're discussing the piece of the statute right now that eliminates life without parole for juveniles. Other pieces of folks' bills who say, we've got to get these, put some of these kids back into society. Well, they're no longer kids. But, some of those other sentiments about don't throw a life away forever, those are different cases. Those aren't the cases I just read to you that are the life without parole cases. And to say those people, you cite recidivism rates, none of those recidivism rates applies to these life without parole people, because you know why? Because they don't have a chance to recidivate, because we don't let them go. So to suggest that we can somehow say, oh, well, they wouldn't recidivate, which really isn't, honestly, it's not really even the issue, because at this point, when you've done something that heinous where the courts impose this, recidivism really doesn't come into the picture, though, does it? Because it's more the fact that what you did was so revolting and disgusting and so harmful to society that recidivism doesn't even enter into the picture. But I think the main point I want to make is just that when we're talking, we bring up people who come in here who have turned their lives around, who did 20, 30, 40 years, and eventually were paroled. I have a bit of empathy for those folks, and it's great to see them moving on. But that's a different class of people. It's a different class of crimes than what we're talking about here. And so let's not, we're trying to, there's a push to conflate those people and say, oh, here's one of these people. But it's not. That's not one of those life without parolers. That's not who you're seeing coming in here, and it's an entirely different matter. And we can all cite to these folks who come back out and who've turned their lives around because they were put in prison for 30 years after 16 years old of armed robbery gone bad. Yeah, we can all look at that, but that's not what we're talking about here. This is a different class entirely. Thank you.
Thank you very much. All right, further discussion on the bill as amended.
You want to talk about the rest of the provisions that would require again year after year to face where the victims would never have any peace? Even you want to get into that just how it allows repeated hearings over and over and over, and the courts have to drag people back in, the victims and their families, or not the victims, but their families, decade after decade to relive their trauma. Should we get into that piece, or you just want to subsume that within the rest of it? There's certainly many more very troubling aspects of this bill, because it also says that for anybody, this also goes into sort of beyond just sort of the basics we're talking here, and provides all these criteria that we're supposed to the judge is supposed to look at, that just very much focuses on the murderer. And then there's this little piece in here about the victims, the statement offered by the victim or the representative out of the 11 factors, because we're not really worried about victims and their trauma. And then we on page 3, it says that we can do these things every 3 years and keep pulling these poor people back into, we can torture them every 3 years like little bugs or something and live happily ever after. So I don't have anything more to say beyond that. Trying to be nice here.
I got it. I appreciate it. Thank you, Senator Castley. Senator Hedelman is next.
Chairman, I guess I'd like to say, this bill is about justice. Justice is being served. People are serving sentences. And like following up on what my colleague from Baltimore City said, when things happen when people are juveniles, we know that brains don't fully develop. They do all their pruning through the age of 25. Somebody is going to be serving 20 years at the very least, and they have to go through a very serious review process that is quite comprehensive. And I recall, I'm sorry I don't remember her name, but a woman who used to work for the state's attorney's office whose brother was murdered, who testified, and I don't think it was on this bill, but it may have been on Senator Kelly's bill, and who was a victim. Her family was a victim. And I remember a number of other victims who have come in and weighed in on bills like this, so their voices are being heard, and they may be a minority. I don't know. I don't think we know, but they are in favor of this, of giving somebody a review process and having the opportunity. Now, some of those are heinous crimes. They are atrocious, and I wouldn't want someone to not be held accountable for them. But I feel like we are holding them accountable, but we're also saying that when they've met a series of very stringent conditions, that we take another look. And somebody who is 15 and is involved in a crime is not the same as somebody who is 35. And we take another look. We look at their behavior. We look at the circumstances of their life at the time. We take into account all those different conditions. And I think it's entirely appropriate that we not judge people by the worst thing they've ever done. And that's why I support this bill.
All right. Thank you very much. There's no further discussion on the bill. The motion is for a favorable with amendment.
Second.
It's been seconded. We'll do a roll call.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Castley.
No.
Senator Hedelman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
No.
Senator Carter.
Standing for justice and with the majority of Marylanders polled that support this proposal, yes.
Senator Huff.
I've looked at that poll. I find it to be fake news. No.
Chairman Smith.
Yes, and explain my vote. Look, I've struggled mightily with this bill for every year that it's been before the General Assembly, every year that I've had an opportunity to participate in the hearings, and just centered, and I feel good. I feel solid and firmly confident in my yes vote. It just comes down to what type of criminal justice system we want to provide here in Maryland, we want to install here. And if you believe in just the shred of redemptive quality of the human condition, I believe this bill just gives affords an opportunity for folks to at least have a hearing. And so gladly casting my vote, my yes vote. So the bill passes as amended. All right. With that, I just have one small administrative matter that I neglected to add an amendment to a bill that we passed to the landlord bill, 686. Can you explain the amendment, Council?
I actually have a question about the amendment.
Sure. Actually, so then the motion is to, I'm going to withdraw, reconsider the vote, bring the bill back to committee so that we can just clarify the amendment. Is that okay with everyone? To recall that vote? Okay, great. Thanks. All right, with that, let's call it a night. Thank you all very much.
No,